Welcome to the deep dive. Today we're cracking open a really pivotal piece of South African law, the Matrimonial Property Act 88 of 1984.
That's right.
And look, this isn't just some dusty old statute book stuff. It's basically the blueprint for financial equality in marriage today.
Absolutely. Our mission really is to cut through all the legal jargon, the section numbers.
Yeah, get past that.
And explain what this act actually does. Its purpose, the key bits, and why it matters, whether you're just curious or maybe cramming for a law exam.
Right.
Because this act, it truly overhauled the whole economic side of marriage. It took us away from centuries of old common law rules and brought in a modern system based on parity, on equality.
It's huge legislation, isn't it? I mean, signed into law way back 40 years ago, but it's still the standard. It's been tweaked, updated right up to April 2024.
And the core aim, if you read the act itself, is pretty simple: to amend the matrimonial property law and provide for matters connected therewith. But the scope,
wow, it covers everything. Marriages in community of property, out of community.
really cast a wide net. The impact just can't be overstated. And I think, we have to start with the biggest, most revolutionary change,
Okay.
which is actually tucked away in Chapter 2, the complete abolition of marital power.
Right. Okay, let's unpack that. Marital power. Before 1984, under the old common law, what did that actually mean in practice? The husband had control.
Pretty much, yeah. It meant serious limits on the wife's legal capacity, her standing.
So, like, she couldn't just open a bank account on her own?
Often no. Or sign a major contract, get a mortgage. She often needed her husband's consent, his assistance. Legally, in financial matters, she was often treated a bit like a minor.
Wow. So Chapter 2 just wiped that slate clean.
Just like that. Section 11 says black and white, the common law rule giving the husband marital power repealed, abolished, gone.
And Section 12 spells out the effect.
Exactly. It says, okay, because that power's gone, all those restrictions on a wife's ability to sign contracts to sue or be sued, they're gone too.
A fundamental shift. Just like that.
Foundational. Towards legal equality within the marriage itself.
And what's really striking is this wasn't just for new marriages going forward, was it? It reached back.
No, and that's absolutely crucial. The Act made its rules about equal powers, which we'll get to in Chapter 3 retrospective.
Meaning,
Section 11 specifically says those equal powers apply to every marriage in community of property. Didn't matter if you got married in 1980, 1960, whenever.
seriously, so women married decades before suddenly had their full legal capacity back. Overnight.
Overnight. Even if they never signed a new contract or anything, their legal status changed instantly. It's quite remarkable.
That retrospective aspect is, well, it's staggering, really. Okay, let's shift gears a bit. What about couples who, don't want to share everything? They sign that contract before marriage.
The antenuptial contract, yeah.
Right. So if they sign an antenuptial contract, or ANC as it's often called, to keep their estates separate, what happens then?
Well, if that ANC excludes community of property and also community of profit and loss, then the Act introduces a default system, unless the ANC also specifically says no to this too.
Okay.
The accrual system automatically kicks in. That's Section 2.
The accrual system.
Right.
This is where we get into the idea of fairness, even when things are separate. It's not just what's yours is yours, what's mine is mine anymore.
Not entirely, no. It's more like deferred sharing. It's about sharing the growth that happens during the marriage, not the assets you each brought in at the start.
Okay, so how does that work? How do you calculate this? Accrual.
So Section 4 defines it. Basically, you look at the net value of each spouse's estate when the marriage ends either death or divorce.
Okay.
Then you subtract the net value of their estate right at the beginning of the marriage.
Yeah.
That difference, that increase, that's the accrual.
Right, the growth. Can
Yeah.
you maybe give us a quick example, make it concrete?
Sure. Let's say spouse A starts with $100,000.
Yeah.
At divorce, they have $500,000.
Okay.
Their growth, their accrual, is $400,000. Spouse B starts with $50,000, ends with $100,000. Their accrual is $50,000.
Okay, much smaller growth.
Exactly. So you find the difference between their accruals. $400,000 minus $50,000 is $350,000.
Right.
Now, Section 3 says the spouse with the smaller accrual, spouse B in this case, gets a claim against spouse A for half that difference.
Half of $350,000, so $175,000.
Exactly, $175,000. The idea is they share the financial fruits, the growth achieved during the marriage partnership.
That makes sense. But
Yeah.
it all hangs on knowing what things were worth right at the start, that commencement value. That must be tricky sometimes, years later.
Oh, absolutely. Memories fade, records get lost. So
Yeah.
Section 6 gives options. You can state the commencement values right there in the anti-nuptial contract,
Okay, that's clear.
or you have another option. Within 6 months of getting married, you can file a separate statement signed before a notary listing those values.
Oh, what about inflation? 100,000 Rand in 1990 is very different from 100,000 Rand today.
Crucial point. The Act accounts for that. It specifically says the commencement value must be adjusted using the Consumer Price Index CPI to reflect its value at the time the marriage ends.
Ah, so it keeps the starting capital's value real in today's terms before you calculate the growth. Smart.
Very smart. It prevents inflation from distorting the whole calculation over a long marriage.
Are there things that just don't count towards that growth? Assets that are automatically kept separate?
Yes. Section 5 lists the main ones. Things like inheritances, legacies, or donations one spouse receives during the marriage. Those are excluded.
Automatically.
Automatically, unless the ANC says otherwise or the person giving the inheritance or donation specifically said it should be included in the accrual.
Okay.
Also, certain kinds of damages awarded in lawsuits are excluded, but we can maybe circle back to that later. Specifically damages for things other than actual financial loss.
Gotcha. Now, what if? What if one spouse starts acting recklessly, spending wildly, gambling maybe, potentially harming the value that the other spouse might eventually claim? Is there any protection?
Yes, thankfully. Section 8 is the safety net here. If you can show a court that your right to share in the future accrual is likely to be seriously prejudiced by your spouse's conduct.
Like hiding assets or wasting them?
Exactly. The court can step in. It has pretty strong powers. It can order an immediate division of the accrual right then and there.
Freeze things. Lock in the value.
Essentially, yes. Calculate the accrual as it stands and divide it. The court can even go so far as to change the entire matrimonial property system if needed.
Wow. But that right to share, it's not absolute. Could you lose it?
You could. Section 9 makes it clear that the right to share in the accrual is considered a patrimonial benefit. And like other benefits, a court can order that you forfeit that right, either completely or partially, during divorce proceedings if your conduct warrants it.
Okay, so there's protection but also consequences. Let's switch back now to marriages in community of property. Chapter 3. If accrual is about equal sharing after, this chapter is about equal management during, right?
Precisely. For those who choose joint ownership from the start, Section 14 laid down the principle. Equal powers for both spouses to manage and deal with the joint estate.
Equality.
Yeah.
But with rules. You mentioned consent earlier.
Yes. Equality doesn't mean a free-for-all. Because actions taken by one spouse can bind the entire joint estate, the law puts checks in place. Section 15 is key here. It sets out different levels of consent needed for different types of transactions. Think of it as protecting the family finances.
Okay, so what needs the highest level? Formal, written consent.
You need written consent for the really big financial moves. Selling or mortgaging immovable property, usually the house.
Makes sense.
Binding the joint estate as a surety, meaning you guarantee someone else's debt. That's a big risk.
Huge risk.
And also entering into a credit agreement under the National Credit Act, like taking out a big loan or financing a car as a consumer.
And for some of those, the law adds another layer, doesn't it? Witnesses.
It does, and it's quite something. For certain major actions, like selling the house or acting as surety, the written consent isn't enough. It has to be given separately for that specific transaction, and it needs to be attested by 2 witnesses.
Wow, 2 witnesses. That feels almost cumbersome. Is the idea just to make absolutely sure both spouses understand what's happening?
Exactly that. It's a serious safeguard. It forces a pause, ensures transparency. It prevents one spouse from secretly signing away major assets or taking on massive debt under pressure, or without the other fully grasping the implications.
Okay. But surely that doesn't apply to every little thing. What about, say, selling old furniture or day-to-day business dealing?
No, there are different tiers. For less major but still significant things, you need consent, but it doesn't have to be written or witnessed. Section 15.3 covers this. Examples include selling household furniture or jewelry from the joint estate,
Okay.
or making donations from the joint estate that might unreasonably prejudice the other spouse's interest. Consent is needed, just not the full formal witnessed procedure.
And the business exception. If a spouse runs a business.
Ah, yes, crucial practical point. Section 15.6. Those strict written consent requirements for things like dealing with shares, investments, or even acting as surety. They don't apply if the spouse is doing it in the ordinary course of his profession, trade, or business.
So a property developer selling a house they developed doesn't need spousal consent for that specific sale.
If it's clearly part of their ordinary business activities, then no, not that specific witness consent. It allows businesses to function without constant spousal sign-off on routine transactions.
Okay, that makes practical sense. But what if consent was needed, say, for selling the family car and it just wasn't obtained? And someone buys the car in good faith? Does the buyer lose out?
The law has to protect innocent outsiders to keep commerce flowing. Section 15(9) addresses this. If that third party, the car buyer, in your example, didn't know and couldn't reasonably have been expected to know that the required consent was missing,
They acted in good faith.
then the transaction is treated as valid. The buyer keeps the car.
Phew. Okay, but what about the spouse who didn't consent? Are they just left worse off?
No, there's a remedy between the spouses. If the spouse who sold the car knew consent, probably wouldn't be given, and the Jane estate actually suffered a loss because of that sale,
Sold it too cheap, maybe.
for instance. Then, when the joint estate is eventually divided, maybe a divorce,
Yeah.
an adjustment has to be made. The value of that loss gets debited, essentially from the share of the spouse who acted improperly.
Right, so it comes out of their half first, fairness restored eventually.
That is the idea.
Okay, bringing it all together. Chapter 4 has some important general rules, especially around damages. You mentioned delicts earlier. Just quickly, what's a delict again?
A delict is basically a civil wrong. Not a crime, usually, but an act that causes harm to someone else, giving them the right to sue for damages. Think car accidents due to negligence, defamation, assault, that sort of thing.
Got it. And Chapter 4 has some specific rules about damages won in delict cases.
It does, and they're quite interesting. Section 18 says if a spouse wins damages for a delict committed against them, say, for pain and suffering from an injury, that money does not go into the joint estate.
It stays separate.
Yes, it becomes that spouse's separate property.
Yeah.
Unless the damages were specifically for patrimonial loss, meaning direct financial losses like lost income or medical bills paid by the joint estate, those might fall back in. But the personal injury part, that's separate.
This next part is really something. Section 18 also says one spouse can actually sue the other spouse for damages, for bodily injury.
Yes, that was revolutionary. Before this act, the whole concept of the joint estate, the unity of marriage, often made it legally impossible or nonsensical for spouses to sue each other for delicts.
But the act changed that.
Completely. It recognizes them as separate legal individuals, even within the marriage. So if one spouse negligently injures the other, the injured spouse can claim damages. And again, those damages become their separate property.
Wow. What if a spouse commits a delict against someone else? Say they cause a car crash. Who pays the damages?
Section 19 sets out the order. First, the creditor, the person who was wronged, must try to recover the damages from the separate property of the spouse who committed the delict.
If they have any.
Right. Only if that separate property isn't enough can the creditor then claim against the joint estate.
And if the joint estate does end up paying?
Then, just like with the unauthorized transactions, an adjustment has to be made when the estate is divided. The innocent spouse effectively gets reimbursed from the other spouse's share for the joint funds used to pay that personal delictual debt.
Okay. The act also seems big on flexibility. Can couples actually change their minds after getting married? Switch from community of property to accrual, maybe?
Yes, they can. Section 21 is huge here. It allows spouses to jointly apply to the high court to change their matrimonial property system after the wedding.
What do they need to show the court?
They need sound reasons for the change. They have to prove they've notified all their creditors. And importantly, they have to satisfy the court that no one else will be prejudiced by the change. It reversed the old common law, once chosen, chosen forever rule. Much more modern.
Definitely. And one last quick one, donations. Gifts between spouses. That used to be tricky.
Very tricky. Often void or voidable under common law, but Section 22 just swept that away.
Yeah.
It simply says donations between spouses are permissible. The only real limitation now comes from insolvency law. You can't give away assets to avoid paying creditors.
Right. Makes sense.
But otherwise, spouses are treated as independent people who can gift property to each other.
So looking back at the whole act, the end of marital power, the accrual system as a default for many out-of-community marriages,
Yeah.
it really did lay the groundwork for financial equality, didn't it? Defined by consent, protection, equitable sharing.
That's absolutely the core takeaway. It tackled centuries of inequality head on. But, it's also clear from the detail, the complex consent rules, the two witnesses, the precise accrual calculations that achieving that equality in law wasn't simple.
No.
It required putting these very specific, sometimes quite intricate requirements in place to balance freedom with security and protect everyone involved. It's a complex piece of legal machinery.
Challenging, for sure, but clearly essential. Okay, a final thought for you, our listener, to chew on. We mentioned Section 10 briefly. It gives the court power to defer payment of an accrual claim. Maybe the paying spouse doesn't have the cash right away. If a court does decide to defer that payment, maybe in a big money divorce. What's the real tension there? What's the ethical tightrope the court has to walk between being fair to the person owed the money and potentially pushing the person who has to pay into financial ruin? Something to think about.